कभी साहब बोलছেন না चलो আরে
पीसी डिस्टर्ब कर For reasons mentioned in the judgment, the criminal revision petition is allowed. The impugn order dated 25/5/2022 passed by learned session judge UPA is set aside. The respondent number 2 and 3, namely San Muso and Doi Komi, are directed to appear before the trial court on 29/2024. And on such appearance, learned session judge UPA shall consider the question of framing charges against both of them afresh after hearing both the sides and after considering the materials on record, and thereafter shall proceed with the pending trial in accordance with law.
Deeply obliged, sir.
Under the signature. For reasons mentioned in the judgment, the appeal is allowed. The claimant, in the considered opinion of this court, is entitled to compensation on account of only loss of estate, and on that count, after computation, he is entitled to a compensation amount of 10,89,695, along with an interest at the rate of 8% per annum thereon, from the date of filing of the claim petition till the date of final realization of the same.
Deeply obliged, sir.
Deeply obliged.
File is not there. Office note is there. One office. Office note. Office note. Third, Mr.
M. Bhatt.
M. Bhatt, learned counsel for the respondent. No one present for the appellant. This bunch of these appeals were disposed of by the judgment and order dated 28/8/2024, dismissing the appeal. Stop. However, today, that is on, however, on perusal of the office note dated 30/8/2024, it appears that in the judgment dated 28, in the judgment dated 28/8/2024, in some paragraphs, one date has been wrongly mentioned, which needs wrongly mentioned due to typographical error, which needs rectification. Stop. This court, therefore, in exercise of its powers under section 152 of the Code of Civil Procedure, hereby corrects the said typographical error. The typographical error pointed out by the registry is in paragraph number 6, G, H, I, J, and K, wherein the date 28/2/2017 has been mentioned as 28/2/2027. The error of the year is hereby rectified by making the said dates as 28/2/2017.
One more small solution. Lordship has already awarded the cost of the appeal, but amount was not mentioned.
No, that has to be calculated by the office
Then,
while preparing the decree.
okay.
The
Yeah.
manner in which decrees, civil courts decrees prepared,
Yes.
they will calculate the costs accordingly.
Then on last submission, Lordship, because the appellant has already deposited the admitted amount before this registry, that may be allowed to withdraw from here itself. So that registry may be directed to release the amount.
So, learned counsel for the respondent has submitted that in these appeals, the appellant has already deposited the amount which was admitted by them to be payable to the respondent. The said amount may be disbursed to the appellant, to the respondent by the appellant, by the registry of this court after proper verification.
Deeply obliged.
पर ये भी चेंबर में जाएगा.
Lordship. Lordship, this eligible bail application, the prisoner is Lordship,
Microphone.
prisoner is Lordship, regular employee in the Department of PWD, was serving as junior engineer.
Was
Lordship.
serving as?
Junior engineer.
Okay.
Lordship, kindly come to page number 10, annexure 1. Kindly see the date of complaint.
Prevention of corruption.
Date of complaint. This is right before this year's general elections. My father-in-law is a sitting MLA, and this year he was about to given the BJP ticket. And complainants here, they are the party workers of BJP, and main complainant is the general secretary of BJP of Likabali, that is the Lower Siang district. So this is nothing but a politically motivated case. Actually, Lordship, the basic allegation is that in the year 2020, a work was sanctioned, and in the year 2021, the work was completed. That allegation, the only allegation is that I took bribe for clearing the bills. Moreover, Lordship,
You took bribe for clearing the bills.
yes,
Okay.
and more so, Lordship, the relevant period was 2021, and they have come in the year 2024, right before election, because one of the complainant is the general secretary of BJP Likabali. Lordship, and moreover, Lordship, if you come to Lordship, page number 25. The
No,
FIR.
FIR is filed on 15/1/2020.
Yes, just before elections.
Now, why are you apprehending arrest now?
Lordship, kindly come to page number 24. 24. There is the FIR. See the registered date. The date is 14 August, after 7 months. 14 August. And in page number 25, Lordship, the second paragraph. The second paragraph, may I read, Lordship? The matter was inquired
Now,
into.
where is the date of receipt of the information?
Lordship, at page number,
But information that column 3B says that information is received on 14/8 only.
no, Lordship, this was filed before the main complaint was filed before the Chief Secretary cum Chief Vigilance Officer on 15 January 2024. After placing this matter for more than 7 months, they have forwarded this matter to the SIC on 14. And Lordship, kindly come to page number 25. The second paragraph, page number 25. May I read? The matter was inquired into through a preliminary inquiry side by its SIC Vigilance PS preliminary inquiry number 3 of 24 as per approval of the competent authority. Lordship, they say that the preliminary inquiry has been done. Lordship, I have never been approached. I have never been inquired. I have never been questioned. That means they have whatever they have done. That is totally documentary evidence.
So I'm appearing on behalf of all Father, my lord.
On behalf of?
Urging Father, my lord, Standing Council, SIC, my lord. Due to some personal difficulty, my lord, the Standing Council is not, today he is not unable to appear before this honorable court, my lord.
What is the submission?
My lord, CD may be called, my lord.
Will
But in the meantime, interim may be granted because it's a very old matter. And moreover, Lordship, there is a recent Supreme Court judgment
not
on
a
PC case.
opinion.
Because just day before yesterday, at paragraph, I especially made a version that few police personnel, they visited my residence at Likavali on plain clothes, inquiring about me. That is the apprehension. Otherwise, I would have straight gone to
No,
go to the
Today,
SIC.
the special public prosecutor is not there.
Yes, my lord.
He
That
has
is-
to be heard.
That is understood, Lordship.
We are fixing it on Monday.
Lordship, because tomorrow also I have serious apprehension because I am a regular employee. I will be hampered. And my husband is regular executive engineer.
You are a woman.
Yes. Item 3 is the wife. Item 4 is the husband. This is totally politically motivated because my father-in-law is now sitting MLA.
No, that nowhere it is reflected. That is only your submission.
No, Lordship, that is in the petition, Lordship, at paragraph 2.
No, that is your submission only that this is a politically motivated. But we have to peruse the case diary.
No, even though Lordship, some protection because till that I will go to the SIC. I will give my full cooperation because I'm going nowhere. I'm a regular employee. Both item number 3 and item number 4, both are regular employee in the post of junior engineer and executive engineer. And Lordship is only the basic allegation bribery, no iota of evidence, only allegation.
Not today, on Monday.
With
Special
some
pub-
protection, Lordship, because
special
otherwise,
public prosecutor would be necessary.
yeah, very well, Lordship. He can be here on Monday, Tuesday, and any day, but some protection till then, because the stakes are high.
No, where is the
If I am
apprehension
arrested,
where is the apprehension that you will be, for 1 month you have not been arrested.
Lordship,
For last 1 month, police has not arrested you.
no, so Lordship. Only on 14th of August, the FIR was registered, and just few days back, it was submitted to the court, the special court.
So for
3 days back.
last 15 days, you were not arrested.
No, at paragraph 7, Lordship, I have especially mentioned that the applicant begs to state that just 2-3 days ago, some personal in civil dresses, most likely from the SIC, had visited the resident of the
Where is
applicant.
what is the allegation?
Allegation
What allegation is grave?
that I took bribe for
Yes.
clearing the bills. No iota of evidence.
That we have to see only.
Lordship,
because
but
this,
till then,
this is after
because
preliminary.
Lordship, they have to show more than prima facie. Supreme Court is in the latest judgment, Lordship. 2024 SEC All Length 274, paragraph 12. It clearly says, Lordship, Because protection is needed, Lordship. Great apprehension.
When can you produce the case diary?
My lord, 3 of September, my lord. Tuesday, my lord.
Tuesday.
Yes, my lord. My senior instructing me that matter may be fixed for Tuesday, my lord.
On Tuesday.
Yes, my lord.
Then till Tuesday,
No, not heard, Mr. What is your name?
K. Saxena.
Heard Mr. A. Saxena, K. Saxena, learned counsel for the petitioning. Also heard Mr.
T. Minky.
T. Minky, appearing on behalf of Mr. O.
Oh, pardon. Yes, my lord.
learned special public prosecutor. Stop. This application under section 482 of the BNSS, 2023 has been filed by the petitioner, Srimati Karpik Gay Nigyor, who is apprehending her arrest in connection with SIC Vigilance PS case number 19/2024. Under section 7 and 13 within bracket 2 of the Prevention of Corruption Act 1988. Considering the nature of allegations leveled against the petitioner in the FIR, this court is of opinion that perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence, call for the case diary. Fixing 3/9/2024 for case diary.
Lordship.
Though learned counsel for the petitioner had prayed for interim protection during this period. However, considering the fact that the original complaint was lodged on 15/1/2024, and thereafter, after conducting preliminary inquiry, it was forwarded to the Special Vigilance PS on 14/8/2024, and considering the nature of allegations made therein, even for grant of interim protection, this court is of view that perusal of the case diary would be necessary.
Let's see, one line may be added that on 3, if they are failed to produce the case diary,
On the
interim-
next date, no.
because I'm
On
sure
that day, you may
that may be
Yes.
observed, Lordship. That may be observed. That interim is open.
that is
Prayer
open.
for interim is
That-
open.
That is always open. Even if I don't observe that, you can always press. Why should I bind the court, which I don't know who will be there?
Obliged, Lordship.
Number 4.
I think same order.
Same order.
Same affair. Same. That is 4 is the husband.
Or is the husband?
Yes, he is a regular executive engineer.
Okay. No, same order, name of the petitioner would be
Yes,
different.
different.
Number 5.
Obliged.
Wait, please, Your Lordship. My Lord, as I was submitting on the last occasion, there will be no direct judgment saying that the judgment that my learned friend has relied upon is incorrect. What has to be taken into consideration, my Lord, is whether that
Yes.
whether that finding,
Observation.
I say finding,
Okay.
even if it is a finding, whether that finds your lordship as a precedent or not.
Yes.
Precedent, my lord, as I was submitting earlier that day also. A judgment is a precedent for what it actually decides. and not what logically follows from it. It is only the, my lord, reasoning and the principle that is binding upon your lordship, not the actual finding.
One more query let me put
Yes.
today. Whether that observation by Supreme Court is a law under 141.
No. Bail law, my lord. In fact, there is not a single judgment on bail that is a binding precedent. One set of judgments when there are normal people are involved, where the Honorable Supreme Court has said bail is the rule, jail is an exception. Article 21, all these things. And there are other type of cases like these two, where criminals, hardened criminals are involved, where this line has been approached. So there is no binding precedent as far as law on bail is concerned. No, the judgment that my learned friend was relying upon, 2008, volume 5, SCC 66. There, in fact, they have extracted a paragraph from, my lord, the Papu
Yes.
Yadav case.
Yes,
The main case is 2004-7 SCC 528.
yes.
My lord, may kindly have 2004-7 SCC 528. That is the main case, Papu Yadav case.
That judgment is written. 2004-7 SCC.
528. My lord, everybody knows who Papu Yadav was, Rajesh Ranjan, the infamous, my lord. And the 2008 case was, my lord, the Sorabuddin, my lord, fake encounter case. All these two cases pertains to cancellation of bail granted by the Honorable High Court.
This Rajesh Ranjan case also.
Yes, yes. So in fact, if your lordship goes through, my lord, if the submission is accepted, then, my lord, the power conferred under section 439 by the statute will be taken away by judicial pronouncement. Cannot, my lord. In fact, this is not the manner in which a judgment has to be read. Judgment has to be read as a whole. The observation here and there cannot be taken into account. There is a simple way of, my lord, interpreting a judgment. How judgment is a precedent, man. Now,
No,
in
but one query.
What?
In this case, Supreme Court is not discussing the facts.
Yes.
It is saying about the law.
no.
What I have understood, rightly or wrongly, Supreme Court has said that though 439, no such condition is mentioned.
My lord, in
But-
fact, if your lordship sees the original judgment, that was a case, my lord, 4 times bail was rejected by the High Court. Ultimately, when they granted it, that was cancelled by the Supreme Court.
Okay.
Now, after that cancellation, independently, the Honorable High Court again took up the bail application, again granted on the ground that he has been incarcerated for a long time. So it is in that context the Honorable Supreme Court has held that in this case, we have already held that 437, this one will apply. So between lease between the same parties, so this will apply. But there is no reasoning, no principle laid down that 437 would apply in case of 439 also. Lordship may kindly have 528, my lord, 2004-7 SCC. Then I will, thereafter I will take your lordship to how a judgment has to be understood as a precedent.
At page
528.
para,
Paragraph starts from paragraph 6. In fact, my lord, late R.F. Nariman appeared, and he was conscious of the fact that that finding was incorrect. And Honorable Supreme Court has also at paragraph 20 held. It was, we have held in this, in the same case, between the same parties. That is why it will apply in this case. It is not even a binding precedent. Lordship may have paragraph 6.
yes.
Mr. R.F. Nariman, learned senior counsel appearing for the appellant, contended that the crime committed by the appellant, my lord, this was a case, my lord, when they followed him and shot dead the MLA, sitting MLA. It was this case. My lord knows Papu Yadav, he was an infamous man. Appearing for the appellant, contended that the crime committed by the appellant is so heinous and gruesome that by itself should have been sufficient to reject the.
Now he is a member of parliament.
That is the greatness of this Indian democracy. This is a man, my lord, who tied up a policeman, inspector, in front of a jeep and shot away both his kneecaps.
That may be the allegations.
That is the thing. Now he's an honorable member. Committed by the appellant is so hideous and gruesome that by itself should have been sufficient to reject the bail application of first respondent. He pointed out from the record, I am reading all this because judgment has to be read as a whole. He pointed out from the record that the first respondent filed an application for bail before the High Court, which was came to be rejected by the High Court as per its order dated 16/9/1999. An SLP filed against the said order rejection came to be dismissed by this court on 7/10/1999. A second application for bail filed by him was also rejected by the High Court on 22/11/1999. An SLP filed against the said order was rejected by this court on 4/2/2000. A third application filed by the first respondent for grant of bail before the High Court was rejected by the said court on 3/5/2000, and the order became final because no SLP was filed before this court. A fourth application for grant of bail was made on 26/7/2000, which also came to be rejected, against which no SLP was filed before this court. The fifth application filed by the respondent for grant of bail before the High Court came to be allowed by the order dated 6/9/2000. Fifth application, madam. But in an appeal filed against the grant of said bail, this court was pleased to allow the said appeal and cancel the bail granted to the respondent as per its order dated 25/7/2001. So already one cancellation done. Thereafter, the respondent filed a sixth application for grant of bail, which was rejected by the High Court on 5/11/2000. Against the said rejection order, the respondent preferred an SLP to this court, which came to be rejected on 7/12/2000. The seventh application was filed with the respondent for the High Court for grant of bail, which came to be dismissed on 13/3/2002. And an SLP filed with the said order came to be dismissed on 10/5/2002. The learned counsel submitted that in this background, that the eighth attempt by the respondent became successful, and the High Court by its order dated 23/5/2003 granted bail to the said respondent, which is the subject matter of this appeal. The learned counsel then submitted that though this court in the earlier order of cancellation of bail had specifically negatived the ground on which the bail was granted by the High Court, still in this round, the High Court by the impugn order again granted bail on the very same ground. These are the facts, madam, which the learned counsel submits amounts to ignoring the findings of this court. He also pointed out the judgment of this court that while cancelling this bail, this court had decided certain questions of law which are binding on the High Court. Still, the High Court, regardless of the said findings of this court, proceeded to make the impugn order without even referring to the same. For example, he pointed out that this court in the said order had held that there was some non-application of mine by the High Court of to the provision of section 437(1)(I) CRPC, which this court has held is a sine qua non for granting bail. He also pointed out that this court has also held in the judgment that there is a prohibition in section 437(1)(I) that the class of persons mentioned therein shall not be released on bail if there appears to be reasonable ground for believing that such persons is guilty of an offense punishable with death or imprisonment for life. Now, my lord, kindly note the next submission by Mr. Nariman. He submitted that this court has held that the said condition is also applicable to courts entertaining a bail application under section 439 of the code. He argued, assuming that the said enunciation of law is erroneous, is aware of this fact. Still, because it is a finding given in the case of the first respondent himself, I will kindly take note of this. First respondent himself. So far as this case is concerned, it is binding precedent unless reversed. So far as this case is concerned, it is a binding precedent unless reversed by the apex court itself in a manner known to law. He submitted that the High Court has not followed the said mandate in the impugn order. Therefore, on the ground, also the impugn will be set aside. So these are the submissions. And he was aware of the fact that there may be an erroneous finding of law. Paragraph 7, we can skip.
Now, this is the submission now.
Yes, I am coming, my lord, I am coming. Now, my lord, will kindly, paragraph 7, the additional solicitor general has argued in the same manner. My lord can skip that. Now, my lord, will see the argument of the learned counsel, senior counsel, for the first respondent, Papu Yadav. Paragraph 8. Mr. KTS Tulsi, learned senior counsel appearing for a first respondent, contended that the observation of this court in its judgment dated 25/7/2001 that while granting bail under section 439 of the code, the High Court is also bound by the conditions mentioned in 437(1)(I) of the code is per incuriam, being contrary to the wording of the section itself. He submitted that the observations of this court in the said judgment that the conditions of is sine qua non for granting bail is arrived at by this court on wrong reading of the section. He further submitted that the power of the Sessions Court and High Court to grant bail is independent of the power of magistrate under 437. Learned counsel also pointed out that the section 430 imposes jurisdiction embargo on grant of bail, other than the courts mentioned in 439 of the code in non-bailable offences. And such a restriction is deliberately omitted in section 439 when it comes to power of the High Court or Court of Session, even in non-bailable cases. In this regard, he placed reliance on such and such. So, this argument was advanced. I am reading this because there is no finding. Why? There is no reasoning, no finding, no principle laid down as to why this finding was arrived at. So that is why there is a simple reason, my lord, why this judgment will not bind your lordship. I will produce the other judgments. 9 we can skip. Now, my lord, will come to paragraph 11. So this argument was advanced, that it is a per incuriam finding. 11. So 11 also they do not say, there's a word used is self in 437. So in fact, bail just cannot be granted. So now see 11, my lord. The law in regard to grant or refusal of bail is well settled. The court granting bail should exercise discretion in a judicious manner and not as a matter of course. Though at the instance of granting bail, a detailed examination of evidence and elaborate documentation of the merit of the case need not be overtaken. There is a need to indicate such orders, reason for prima facie concluding why bail was being granted, particularly where the accused is charged of having committed a serious offense. Any order devoid of such reasons would suffer from non-application of mind. It is also necessary for court granting bail to consider, among other things, the following factors. So they have laid down some illustrative conditions. These are just guidelines. This paragraph itself shows that the power conferred under 439 has not been taken away. How can it be taken away in any case, my lord? Conferment of jurisdiction is a judicial function. Even the Honorable Supreme Court cannot take that away. No court is inferior to anybody, my lord, any court. There is a settled law. Your lordship sitting in the High Court cannot.
No, before that, when the counsel appearing for the appellant, Mr. R.F. Nariman,
My lord.
he made submission
Yes.
at page 533
Yes.
that, for example, he pointed out that this court said in the said order, which order it is referring to,
There was another order, my lord, where my lord bail was rejected by this honorable court.
by which court? Supreme Court.
By the Supreme Court. Between the same parties.
And while rejecting, it gave an observation.
Yes.
Where
In
is
fact,
that?
Mr. Nariman is
That is not
conscious of
re-
the fact.
That is not reported.
No, that is not reported. Mr. Nariman is conscious of the fact that is an erroneous finding. He has submitted here. My lord has seen that. Why I pointed out
Okay.
paragraph 8, because there is a categorical submission that it is a per incuriam finding. This judgment goes on. There is no reasoning, no finding that even under 439, 437, 1I has to be taken into consideration. So that type of judgments, my lord, such observations has no binding force upon your lordships.
No, make one thing clear. This, for example, he pointed out that this court in the said order,
Yes,
which one is that order? Which order is?
just a moment. Must be, my lord, 10/5/2002. Where the SLP file in the same order came, no, my lord, no. 25/7/2001.
But 2004,
This is reported, it is in this book itself,
539.
539. Now, my lord, will see paragraph 14.
Okay, we'll go to that judgment also.
My lord, we'll read this first, my lord.
Okay,
My lord will come to paragraph 14.
because in that judgment, Supreme Court for the first time
Yeah.
said.
Yeah.
So what was the context we have to look?
Man,
We'll go to that paragraph later on.
yes.
Now, yes.
My lord will say 539. My lord will kindly directly come to that first.
Five, 3, 9. Yes.
Paragraph 8, nothing. We refrain from explaining any opinion on the merits of the rival contention raised before us. We have noticed from the impugnation there is no application of the High Court in providing the aforesaid clause, which is sine qua non of granting bail. in the light of specific prohibition contained in subclause that such persons will not be released if there appears reasonable ground for believing the regulation of his judgment such and such. Paragraph 7 also. One is that the respondent was in custody for more than 1 year and under the High Court made some observation previous order. We may point out that the previous order referred to, the High Court only made a mention or respondent could renew the application of that observation is not ground envisaged under 437(1)(I) of the code. Where is the reasoning and the principle, man? This is the first order. This is where this first observation came to be made. My lord, bare reading of paragraph 7 and 8. Where is the law laid down, my lord? In fact, there is no law laid down in any of the bail cases to be a precedent. All are illustrative guidelines. Once I take your lordship through the judgments, wherein the Supreme Court has provided as to how judgment has to be read as a precedent, everything will be clear.
Now, where in this case, the second case,
Yes.
Supreme Court said that 437(1) is.
Yes, yes. Paragraph 14.
No. Let us go to that judgment later on.
My lord.
First, the judgment where in the judgment which you are reading,
Yes.
Supreme Court referred to an earlier judgment,
This is 539.
539.
Yes.
My query is, where in 539 Supreme Court said that,
Paragraph 7 and 8.
let us read 7 and 8.
That is why I was pointing out, there is no reasoning, no
Yes,
principle laid down.
first let us
Yes.
read.
As we have noticed that the High Court considered only two grounds for granting bail, paragraph 7.
Okay,
One is that the respondent was in custody for more than 1 year, and the other is that the High Court made some observation in the previous order. We may point out that the previous order referred to any High Court only made a mention that the respondent could renew the application after framing of charge against him. The observation is that observation is not a ground envisaged under 437(1)(I), but they were exercising powers under 439 of the court for granting bail. We are of the definite opinion that the High Court did not approach the bail application from a legal angle. We refrain from expressing any opinion on the merits of the rival contentions raised before us. So there is no finding. We have noticed from the impugned documents, judgments, that there is no application of mind of the High Court from the angle provided in the aforesaid clause, which is sine qua non for granting bail.
this
This is a finding without reason and principle.
we have noticed
Yes.
that in High Court, which is a sine qua non for granting.
See, which is sine qua non means 437(1)(I).
We have noticed for the in judgment, there was no application. But now, this appears to be contrary to the statute.
Yes, and my lord, the main thing your lordship has to know is, as I was submitting, but I will take your lordship to the judgments of precedent. Only the reason and the principle can be a precedent, not the judgment. So this finding can never bind your lordship.
But in later judgments, Supreme Court said that that we did observe in such, it did not rectify itself.
It was relied.
No.
It was relied.
We have to see,
It was
my lord, we are officers of this court. We have to assist our lordship in a proper manner. What is the manner in which the judgment has to be read? I am not making any submission out of thin air. Is it the law that this is binding? Let my learned friend say, so is these two paragraphs binding as a precedent on lordships? This 7 and 8, how can it be, my lord? And I will take your lordship to the subsequent judgment that I was reading earlier. Reading of the whole paragraphs, your lordship will ultimately see it was because 539 they have held so, and it was between the same parties. That is why they have said so. How can this be a precedent, my lord? If your lordship holds that this is a precedent, meaning thereby no longer bail.
Yes.
How can it be?
If it becomes precedent,
Yes.
then we cannot exercise the power of
439 is gone.
439 is equal to
It
437.
becomes redundant.
I will clarify it, Your Lordship.
Okay.
My lord, we have to see just how this is a bail application, my lord, because of submissions made, my lord, we are now arguing for more than an hour on such matter.
We may spill over to other day also if the matter is not clear to me. You have to assist this court to clarify this court.
It is, my lord, in my humble understanding, very, very simple. There is no reasoning, there is no principle laid down, just a simple finding. Is my learned friend saying that is a precedent?
No, what in para 14?
Yes. So my lord have seen 7 and 8.
Okay.
Then, paragraph 14.
8, in para 8, High Court has just given an observation
Yes.
without giving reasoning. Because 437 apparently appears to be applicable to only magistrates court.
Yes.
And 439 does not stipulate any such condition.
Yes.
Then on what basis Supreme Court made?
Yes,
an-
that is what I am submitting, my lord.
That has not been
Yes,
clarified.
when there is no reason and no principle laid down, that cannot bind your lordship. That is the simple law, my lord.
No, but my query is, this is not the only mention, only single time the Supreme Court mentioned it. In subsequent judgment, it again referred to that.
Yes,
We had-
there also no reasoning. There is also no reasoning. You may say right, but
Why-
there is reasoning there.
No, by holding in subsequent judgment, it did not clarify that
Yeah.
earlier we were wrong.
That
Rather,
is why I was pointing out. I was pointing out. If you are my learned friend, all can show that this is how precedents are to be
yes.
by this court.
Make yourself.
You are now on this side. Next time onward, you have no bail. That would be the finding. No more bail in cases where imprisonment for life and death is prescribed. Is that the law, my lord? Now they are on the other side, so they are submitting in this manner. Is this the way in which precedent are read, my lord?
Yes, read 14.
Yes. This is a preposterous argument. We have already noticed from the arguments of learned counsel for the appellant that the present accused had earlier made 7 applications for grant of bail which was rejected by the High Court. And some such rejections have been affirmed by this court also. It is seen from the records that when the 5th application for grant of bail was allowed by the High Court, the same was challenged before this court and this court accepted the said challenge by allowing the appeal filed by the Union of India and another and cancelled the bail granted by the High Court as per the order of this court made in criminal appeal number such and such dated 25/7/2001, 539. While cancelling the bail, this court specifically held that the fact that the present accused was in custody for more than 1 year and the further fact that while rejecting an earlier application, the court had given liberty to renew bail application in the future were not grounds envisaged under 437(1)(I) of the court. This court also in specific terms held that the conditions laid down under 437(1)(I) is sine qua non for granting bail. This sentence itself is, my lord, contradictory. If it is sine qua non, then no more bail as far as those punishments under for life and, my lord, death is concerned. It is sine qua non for granting bail even under section 439 of the code. In the impugn order, it is noticed that the High Court has given period of incarceration already undergone by the accused and the unlikelihood of trial concluding in the near future is grounds sufficient to enlarge the accused on bail, in spite of the fact that the accused stands charged of offences punishable with life, imprisonment, or even death penalty. In such case, we are opinion to the mere fact that the accused has undergone certain period of incarceration, 3 years in this case, by itself would entitle the accused to being enlarged on bail, nor the fact that trial is not likely to be concluded in the near future, either by itself or coupled with the period of incarceration, would be sufficient for enlarging the appellant on bail given the gravity of the offense. Alleged is severe and there is allegations of tampering with the witnesses by the accused during the period he was on trial. So here also, no principle is laid down. They are only saying we have already held so. Am I clear, my lord, on this? Now, my lord will kindly have paragraph 18. What the Supreme Court has said.
Para
18.
Yes.
We agree that a conclusive finding in regard to points urged by the both sides is not expected of the court considering a bail application. Meaning thereby, they did not even consider the arguments advanced by the learned senior counsel KTS Tulsi. So there was no finding.
We agree that a
Yes.
conclusive finding with regard to points.
Subsequently, there are observations as regard to the facts of that case.
Yes.
Am I clear, my lord? Because today, if your lordship holds that this is a binding precedent, then, my lord, there is no longer bail, my lord, which is not envisaged by the statute. 439 is a specific power granted to the Court of Session and High Court. Now, my lord, to kindly have paragraph 20. This is a preposterous argument, actually.
But before the Supreme Court, the counsel for the appellant, Mr. Nariman,
Yes.
he himself argued that unless the observation is reversed.
No. I'm coming to that. Your lordship may kindly have that paragraph again.
Yes.
Paragraph 6. My lord, will it be possible, my lord, if your lordship is leaving today, will it be possible that this can be decided, my lord? Ultimately, if somebody is under incarceration.
Yes, it is. This matter is disturbing me also. And what do you suggest?
If your lordship has to carry this, because on this point, I will have to argue lots,
Yes.
maybe
Because
around
this-
2 hours now.
I don't know whether what recourse maybe this court may have to be taken,
Yes.
because this is a observation made by Supreme Court. Had it been made by a larger bench of this court, I would have referred it to for
But-
clarification, but it is by
But
Supreme.
the fact remains, my lord, this is not a binding precedent.
Yes.
Very simple.
That
I could have
that-
shown, my
that-
lord, but the difficulty
that-
is, today is the last day.
That observation, to bypass the observation made by Supreme Court, that finding has to be given that this is not a binding precedent. Then we can bypass that.
In that case,
But-
my lord, can it be on Monday or Tuesday, my lord?
I will be happy.
Otherwise, my lord, what
But-
I see,
but-
this is a very, very simple,
But
Thing.
this is a very important issue.
with
which-
the
which
greatest respect,
it
my
is-
lord, that
it-
is
No,
there,
it
that
is
is
for the
there.
bar to make it clear.
If I am saying we are not going to argue
No,
today,
no.
I am
he
even not
is-
completed my
he
argument,
is
if your
not
lordship
com-
is
he
not
has-
taking up,
he
what
has-
is the,
He has not
Well,
completed
clarify.
his argument. And this is, I also tried to find out the way out. Because what is my understanding? If so, what has been held by apex court in Rajesh Ranjan case is the law, then the hands of Supreme Court and Sessions Court are also tied.
that,
Then it is just
cannot
like a
be that.
magistrate court.
my lord, may I pray, my lord, since your lordship will be leaving today, it may be difficult. So in that case, let it be on Monday or Tuesday, my lord.
Okay.
Hopefully.
Your Lordship, only in one aspect,
My
later
lord, we are not arguing anymore.
Now let him.
clarification, I am not arguing the law, Your Lordship.
Yes.
To what extent the Supreme Court take it further, Your Lordship? And recently also, Your Lordship, 2024 it says itself, Honorable Supreme Court again relied this
Yes,
judgment.
very well.
And Your Lordship,
Let-
the
We are
issue,
not hearing.
That's
Just
what I'm
for my
saying.
clarification.
the issue here is, the Supreme Court says the incarceration period cannot be taken into consideration. Why? Because of that spirit taken from 437(1) subclause 1.
In that light, it has to be understood.
Yes, Your Lordship.
But Supreme Court also said that 437(1)(1)
Yes, sine qua non.
sine qua non.
Yes, Your Lordship.
Then how will you overcome that observation?
Your Lordship,
Unless-
Supreme Court has clearly held, if in heinous offense, Your Lordship, we have to understand one aspect. Heinous offense and normal, Your
Assume that every 302 case is a heinous.
Your Lordship, in Biru, Pakapa, Goda, and another verses, Your Lordship, state of Karnataka, therein, Your Lordship, the Sanjay Chandra Sarkar case was also distinguished, Your Lordship. That law will not apply in the case of the heinous offense. It has been held by the Supreme Court, Your Lordship. It has been clarified that this law is relevant for the other offenses. But so far as the serious offense, this heinous offense is concerned, that is murder, this law will not operate, Your Lordship. It has been distinguished by the Supreme Court, Your Lordship.
No, I'm not, as because the petitioners council has sought some time. Otherwise, assuming that what has been observed in Rajesh Ranjan's case,
Yes, Your Lordship.
that 437(1) embargo is a sine qua non even for 439 courts. That is for High Court as well as Sessions Court.
Yes.
What would it mean? It would mean in every 302 case, if there are materials, that reasonable materials that he may be guilty, you cannot grant bail.
Yes, Your Lordship.
So is that an absolute embargo like 37 or
Preposterous.
Your Lordship has to
Preposterous.
look into the provision of this concept of under trial prisoner also. Otherwise, in all cases, after investigation, a person is entitled to bail even if he found to be involved in commission of the offense. Then there is no any concept of under trial prisoner, Your Lordship. It is also one of the aspects. That is why 436A specifically says in the punishment, if it is death, then 436A again it will not apply.
what is your line of argument? You want to say that what Supreme Court said, that is the law
Yes, Your Lordship.
in Rajesh Ranjan.
Yes.
It is.
They have to overcome that. The prima facie, if the court is satisfied that the person as on that when the matter come up before the court on the basis of the material produced before the court, if court find that the role, considering the role of the accused, if court find that there is no satisfactory ground to believe that the person is guilty, then court can grant bail. But if court find a prima facie material role, he is directly involved, then court may not grant bail, Your Lordship. This is my understanding so far as this
have
provision is concerned, Your Lordship.
22 years, my lord, my learned friends are teaching me things that I have never heard of. We'll argue, my lord. We'll see what is a precedent.
Okay. Mr.
It's a simple law, actually. Powers under the statute are sought to be taken away.
Mr. T.
Preposterous.
We have to assist this.
We'll see.
There is not a complete bar, Your Lordship. They have to overcome that part.
To overcome that, there has to be
No, what they are submitting, if
Difference
Rajesh Ranjan is law, then your lordship's powers under 439 so far as
Curtail.
totally curtailed.
not curtailment.
Not
To
absolutely
an
curtailed.
extent,
Not
to an
absolutely.
extent. Which,
To some extent,
to
it
some
is-
extent.
to some-
which-
yes,
which
Lord.
Statute.
How
gives-
can, my lord, the finding
statute
be
gives no
in
bar.
Yes.
Statute is very clear that in 437 itself, it makes very specify clearly
Yes.
courts other than high courts and
Yes.
sessions court.
Yes.
437 conditions are applicable to courts other than high court
And
and
session court,
sessions
that
court.
magistrate.
When statute is without any ambiguity, excluding high court and sessions court. And if by a judicial pronouncement you are bringing it, there has to be some reasons. Why are you bringing it?
I wish
But-
your lordship had
But
time. my lord, I could have
439
shown.
does not discuss the reasons.
Yes, Your Lordship.
In Rajesh Ranjan's second case, where for the first time it observed, it does not discuss as anything.
Yes, Your Lordship. But later on, Your Lordship, prior to that, I have indicated, Your Lordship, what judgment, where in the first point, Your Lordship has pointed out that if this, we take it into consideration that whether prima facie case or reasonable ground to believe that the offense has been committed by the accused. That was even the parameter laid down in the other subsequent cases, Your Lordship. Although it's not specifically mentioned, 437 subsection 1 and subclause 1, but that portion, that provision of that, the 437 subsection 1 is specifically mentioned in the subsequent judgment also of the Supreme Court, Your Lordship. And recently also, Your Lordship, considering that this judgment held in Kalyan Chandra Sarkar, the Honorable Supreme Court has, Your Lordship, has not taken into consideration the Supreme Court held that even if he is in custody for 2 years, if he is found to be involved in the offense, then
But it has given the bail in for incarceration in some other cases.
The death in other cases, but here in this case, it's only 73 days. And now the
No, let us.
actual expect, your
Let
lordship.
us not go into that. Heard Mr. Dicky Pangi, learned counsel for the petitioner. Also heard Mr. T.A.T., learned additional public prosecutor, as well as Mr. K. Tama, learned counsel for the victim. Learned counsel for the petitioner submits that as the hearing of this bail application would require much time.
My lord, may kindly frame the issue.
I
As
have
to
already-
whether
I have already,
Rajesh Ranjan is binding, my lord,
yes, that I
and
have,
takes away the power under 439.
that I have
That
already,
is already
in
last date.
last date I have put up there.
Therefore, since that is already in the record, this
It-
has to be decided.
It has to be decided. I'll follow this. The council prays for listing this matter either on Monday or Tuesday.
Monday.
When,
Let it be on Tuesday.
Tuesday, your lordship.
considering the submissions made by learned councils,
In the
Let
case, my
this
lord, Wednesday, my lord.
let
No,
this,
no, somebody is in jail, come on, not that.
Then Monday.
let
Monday,
this,
it's urgent, Monday.
Urgency is mine, I am in jail,
when do you want?
Tuesday, man.
Okay. On 3rd of September 2000.
Okay.
Avlai, JP Avlai.
Item number 6.
Lordship, yesterday I came to know through post list that Article Islam has filed this criminal revision petition. So, Lordship, I will appear on behalf, I'm appearing on behalf of the complainant in this case, Lord. So my client is out of station due to medical reason. So I have already informed my client. So client has said that some time may be taken after completion of medical issues. So Lordship,
You are for,
a complainant here. So far, I have not received this copy also.
you are not even made party in this case.
Yes, I don't know, Lordship.
But yesterday, Lordship, they have filed
Yes, I
IA,
have
Lordship.
filed
I have received the IA today morning. I have.
You have filed an IA.
Yes, I have.
Where is the IA? IA number 78.
So Lordship, I may be given 1 week time to file the Bakalatnama after coming back.
Where is the
client-
IA?
I this morning only I have received the IA, Lordship. I have also not gone through.
Huh? No, wait. In the cause list, it is, IA is there.
IA is there, Lordship. Lordship, may
70.
It must be there.
17, no?
Am I audible, my lord?
Oh, yes, just a minute. In item number 8 and item number 7 are. In item number 8,
Lordship, item number 7,
Number
Lordship.
6 and 7.
item number 6 and item number
Seven.
7. In
Yes,
6, you have not made,
Made, I have made.
Item number 6, Lordship, they have issued a notice upon response to Lordship. I have gone to the record, Lordship.
item number 6.
Yes, Lordship. That is the earlier, Lordship, that was, I was appraising this court that
Yes,
today it
who-
was
Who
fixed,
is
Lordship.
respondent number 2 in item number 6?
My lord, in item number 6, revision
yes,
number
you
11
are
of
made party.
2024.
I have not been made in party, but Your Honor, I have come to know from yesterday the post list that Article Islam has filed this revision petition. So Your Honor, from the day of initially, I am the counsel for this complainant. So my client is now.
Yes, Mr. Sharma, what is your,
My lord, what happened here? The lords will come, kindly come to, in item number 6, my lord, the revision petition number 11.
yes. In 11, the respondent number 2's counsel has appeared today and he is seeking time
To file the Bakalatnama.
to file the wakalatnama.
I need at least, Lordship, 5 days.
Yes, you make
My
your
client is
submission.
out of
There is a
country.
connectivity issue. Yes, any submission?
My lord, item number.
Yes, my lord, page 41 also may kindly come. In revision petition number 11 of 2024.
No, Mr. Sharma, there is a connectivity issue in what I was saying, that counsel for respondent number 2 has appeared today
Yes,
and is seeking time for filing.
but I am on interim order, my lord, because your lordship kindly come to item number revision petition number 11, page 41. How the order was passed by London magistrate without hearing me, and my money is being defreezed and transferred to the account of the complainant illegally, and that is not called Zimma. What is Zimma under section 451? When the money is safely in the bank, in the frozen, why it should be released until inquiry and trial is over? What the section says in 451? Kindly come to my section 451 of the CRPC.
Please,
So the money should have released until the trial and inquiry is over. Now what happened here? Expiry order is passed in my absence by the JMFC, and the police should go to the bank, defreeze the amount and release in the account of the complainant.
No,
That
just
is
a
not
minute,
done.
just a minute, Mr. Sharma.
Yes,
Whether in this case,
yes.
the money has been already released.
So far this amount is concerned, my lord. This in page 41, my lord, in item number 6, money is released and he has
Has al-
appropriated. It can be done.
Has already been released.
Yes, that is
Then
illegally
what is
done.
your- Then what is your prayer?
Now prayer is in item number second item, my lord. Revision
No,
page 12.
but let us go one by one.
Yes,
In this item, you are praying for time, then we'll grant time. We'll come to second item.
yes, second item. In second item, a lordship
No,
may
no,
directly
just
come
a
to
minute.
page.
No, just
Yes.
a minute. Let me
Yes.
pass orders in this item.
Yes,
Heard Mr. R.P. Sharma, Lanet, Senior Counsel for the petitioner, assisted by Mr. A. Hussain. Also heard Ms. L. Hage, Lanet, Additional Public Prosecutor. Mr. T. Topung, T. Topu, Lanet, Counsel for the respondent number 2 has appeared and prays for some time for filing Wakalatnama, as he has been engaged by the respondent number 2 only today only. Stop. The prayer is allowed. Whether trial court record has arrived? The scan copy of the trial court record has arrived. Let the same be placed with the case record. Let this case be listed.
one more prayer in this case, my lord, that since the amount were released and already gone to the account of the complainant, let him not appropriate the amount, because it should be in the safe custody, even if it is given to him. Let him not appropriate to his interest,
Within this period,
because
Lordship,
the money should be in the custody of the
when
court.
instruction,
And Zimma is given to a person who take the Zimma on behalf of the court.
No, we will consider the proprietary of
yes,
this order later on.
Yes.
Now, as because there is no scope of any interim relief.
Yes.
Money is not in the bank.
Yes.
It
Only
is-
one observer there, my lord. The release of the amount in this case, as per order dated 20th of June 2024, shall be subject to the outcome of the criminal division petition number 11 of 2024. That observation I made.
Lordship, my prayer is only, Lordship, I may be given to time to file Bakalat.
Because Zimma doesn't mean that he would appropriate the amount.
And meanwhile, Lordship, exactly let us bring the truth, all the case there also, Lordship, then it will come, what is the main role?
It is a collision FIR.
I can produce case study, Lordship.
But when we can fix it?
Because the matter is still in investigation, charge is not has been
When
filed
we
yet.
can fix it?
On 6th September, Friday.
Let this matter be listed again on 6th of September. it also appears that perusal of the case diary of Naharlagun PS case number 14/2023 would also be required for consideration of this criminal revision petition. Hence, learned additional public prosecutor is requested to produce the case diary on the next date fixed. Let this matter be listed again on 6th of. Then
Plan.
next matter is there is an interlocutory application wherein a prayer is made for impleading you as a party that we are allowing, that we may allow. Ms. Hage, you have any objection?
No losses, because it's already in the partly in the other item number losses, 6 losses.
Third, Mr. R.P. Sharma, learned senior counsel, assisted by Mr. A. Hussain, learned counsel for the petitioner. This interlocutory application has been filed by the applicant Atikul Islam for praying for impleading the whom you want to implead.
Respondent number
Phone number 2.
Name.
Narang Rikam.
That is I.
Nangrum. Nurang Rikam as respondent number 2 in this case. Learned counsel.
Madam, page 30, the implement order is page 30. The amount has not been released yet.
No, we are coming to that later on. We are
Yes.
taking up interlocutory application now.
Oh, yes.
The learned counsel for the petitioner has submitted that though Mr. Nuren Rikam is a necessary, who is the complainant in Naharlagun PS case number 14/23 would be necessary for consideration of this revision petition, consideration of the connected revision petition. However, due to inadvertence, he was not impleaded as the party in the connected criminal revision. Hence, he prays for allowing this petition. Ms. L. Hage, learned additional public prosecutor, raises no objection. Rather, she submits that the party sought to be impleaded is in fact a necessary party. Stop. Considering the submissions made by learned counsel, the prayer is allowed. Let Mr. Nurang Rikam be impleaded as respondent number 2 in criminal revision petition number 2024. This
20 losses, 12 to
12 of 2024. This interlocutory application is accordingly disposed of. The registry shall make necessary. No.
I have not received.
Yes, registry shall make necessary correction in the application. Now, this interlocutory, this criminal revision petition, we can take it up after making correction, and you have to supply the copy.
Yes.
But their apprehension is that you have already withdrawn the money.
I have lordship, I have withdrawn only
In
19 lakhs, now remaining 13 lakhs. Already that part is already, Honorable Learned Judicial First Class has allowed the GMA application, and we have submitted this order before the Bank Authority. So still they have not released. Partially out of 36 lakhs losses, only
now their apprehension is that this
30, 30, madam. Yes,
36 lakhs.
yes.
out of 36 lakhs lordship,
How much has
19
been
they
released?
already withdrawn.
19 lakhs already withdrawn.
How much is remaining?
Now remaining is.
Now 13 lakhs,
13 lakhs.
89,543 is remaining.
So that is also already Learned Judicial First Class.
They cannot, my lord, take the money and appropriate in their own account.
And that order we
It
have.
is simply in the bank account, my lord, let it remain in the bank account, let the amount be remain frozen.
Lordship.
It will not harm anybody.
No, Mr. Sharma, the
Yes.
question is, we can hear the revision petition only if he is made a party. You did not
No.
made him a party.
Yes.
Now we have directed impleading him as a
Yes.
party.
Yes.
Now the registry will make a party. You have to supply the copy of petition to the,
Copy will be supplied today, is the matter.
it has,
Only there, since the learned friend is appearing, my lord, in this case
Thereafter,
also,
Lordship,
today.
whether this honorable
Learned
court
friend for
consider
complainant is,
the order,
let me just complete.
All this correction only.
Learned friend for the complaint is appearing in this
My
case
prayer is
also.
that, Lordship,
Let
now
him not,
consider
let him not, my lord, prejudice
have
the
taken 3 crore with,
petitioner here by withdrawing the money in collision with the local police. Let him not draw the money. Since the matter is sub judice before a lordship, my lord, certainly a lordship will have to overlook that, oversee that.
Lordship, today I only need the adjournment because I have to go through that criminal revision petition also. And even I have to take instructions from also.
no, but their main use, if you give an assurance that you will not draw money till Monday.
Lordship, Honorable Court Judiciary First Class UPA has already on 25th July 2027.
No, that order they are challenging actually.
So now thing is that the police is.
That order is also challenge, my lord. Let him not for, until the petition is taken up for hearing, my lord, let him not withdraw it.
So
They are in collusion, my lord, with this one, Hemant Agarwal, and they are drawing the money, my money, my professional money.
Moreover, in this case, what happened?
How can they draw my fixed deposit?
No, not in this manner.
So it is my money, your.
No, not in this
No,
manner.
no, not your money. It is my legal professional money. How can
No,
you claim? You have paid to one Hemant Agarwal in collusion with
My
Hemant
prayer is
Agarwal.
that Lordship,
You have filed a false
Mr.
FIR
Sharma,
against me.
Mr. Sharma,
Consider interim prayer.
Yes.
I am on procedural. Procedure has to be followed.
Yes.
Just now we have
That is true, my lord, but
impleadment of respondent number 2.
yes.
So he has
Now,
to
only-
be impleaded and copies is to be furnished to him.
yes.
Only then we can hear your.
No, that is true, my lord. Only one submission. Lordship may kindly bear it. Since he has appeared, it is not his money. According to the FIR, he paid the amount, so-called amount, whether it is really or not, 3 crore in cash. This is not believable to one Hemanta Agarwal. Hemanta Agarwal is not arrested by police in last 8 months. Not the Ibomboje. They are trying to hoodwink me by filing a collusive FIR in collusion with Hemanta and my lord the Ibomboje. They are taking my money,
You take
legal,
one
my
only.
hard-earned money.
You take a copy of. You make your submission on interim application at least. Will it be possible?
Lordship, today it will be impossible.
Till then, the bank will not release the amount.
Lordship, that client has
He has already appeared in, he has even heard now.
It's out of this due to medical reason. So, Lordship, very simple thing. Let the registry be make it clarification regarding this.
Money is in-
After that, next week it can be whether this court if appropriate that the June can pass. If not, then the June will be rejected. So today only Lordship time will be allowed to.
Now the account has been freezed.
Account is Lordship freeze, but after that Lordship we have filed the deny application. Initially we have filed one deny application for all total of 36 lakhs. The court has allowed, but because of RDA, again Lordship we have got letter from ICA, that's concerned bank. So we have filed one IA before the same court. So again that Learned Court below has passed order to release the remaining amount. So that order we have submitted before the concerned bank, but still almost still the amount is not been submitted, not been released to the complainants. So meanwhile they have filed this criminal revision petition. So today I am saying all the time, don't grant any interim relief. My prayer was.
No, Mr. Sharma, this defreezing order is of 26/2024. That is about 2 months ago. Oh, Mr. Sharma is not there.
Network. A lot of distance. It is not audible sometimes, it is not visible.
No, this defreezing order was of 2020 June 2024, more than 2 months earlier. 2 months ago, you are challenging this order now. Now, how would we know that money has not yet been defreezed and it has?
The lordship, criminal revision petition 12 lordship, they have challenged the order of 27/2024, that is July lordship. Until now lordship, they have not withdrawn the money.
We
As
have
per
not
the,
withdrawn the.
no lordship.
Let him
as
not
per the-
withdraw now.
That's why lordship, it is still pending lordship. There's no chance that this is not urgency that it will withdraw today
if
or
you
tomorrow lordship.
You may give an assurance.
Lordship, we have already given that.
Then I will defer this matter on your assurance. I will not pass any orders because procedural compliance has yet to be made.
We
You
have already lordship submitted.
Yeah,
this,
let him not withdraw
Lordship,
money
in
until it's taken
July
up.
2000, that second order, we have already submitted the concern bank. Now, thing is that bank has still not released that amount, the remaining amount.
Today is bank holiday.
Yeah, today's bank holiday. Tomorrow the
Saturday.
bank-
But lordship, from July to till that lordship, bank is also not releasing amount lordship as per his submission.
Yes.
So that means lordship, this is no urgency, and maybe they have already asked the bank to not to release the amount lordship. That may be possible.
Yesterday-
It could be possible. That's why lordship, till now, if bank is also not releasing money, then
My-
what's the urgency
My
lordship?
lord, just a minute.
Very s-
No lordship may go through
The
the
bank,
lordship.
why my lord not release the amount? As because my lord, two FD. FD was not matured. Now FD got matured. That is why lordship. MN is available. In
Till next date, till next date, we are putting a halt till next date.
Lordship,
Because
no need of interim order because we are also not frequently asking the bank authority to release, but we have submitted the order. Only we are waiting when they will release the amount. So it's not urgency, Lord.
no, you are not giving an assurance to the court.
Assurance, Lordship. since
Therefore, we are putting a halt.
Lordship, till Friday, Lordship. Till
Till-
Friday.
oh,
this matter
yes.
will be-
Till Friday. Heard Mr. R.P. Sharma, learned senior counsel, assisted by Mr. A. Hussain. In this correction will be done by the registry today itself. In connected IA number 78/2024, the complainant of Naharlogun PS case number 14/23, Mr. Nurang Rikam has been directed to be impleaded in this criminal revision. Registry is yet to take steps. However, Mr. What's your name?
T. Topu.
T. Topu, learned counsel for the T. Topu has appeared and submitted that he has been engaged by Mr. Nuran Rikam today only, and he needs some time to file the wakalatnama. As the registry is also yet to comply with the order dated 31/8/2024 passed in I number 78/2024.
Number 12 lordship,
I number is 78.
17.
but well.
That impleadment petition 78/2012. Therefore, let this matter be listed again on
Lordship, 6th of September.
6th of September. However, considering the nature of issue involved in this case, the ICICI Bank Naharlagun branch is directed not to deposit the money, that is rupees 13,89,543 into the account of Nurang Rikam as directed by the Court of Learned Judicial Magistrate First Class UPA on 25/7/2024 in criminal misapplication number 184/2024 till next date, that is till 6th of August.
September.
Till
September.
6th of
Oblige, my lord.
6th of
September.
September.
Deeply
list-
obliged.
List according on till 6th stays there. Finish.